Hello, this is Alexander Cross, attorney criminal defense here in the San Francisco Bay Area. If you'd like to learn more about criminal defense here in the San Francisco Bay Area, be sure to subscribe to our channel, Law Offices of Cross and Associates. So we received a question here on our YouTube channel. Let's see, I was stopped for driving without a seatbelt, and when the cops pulled me over, they discovered that I had not appeared in court back in 2015 for a petty theft case. What could happen to me? Well, in a situation like this, you more than likely have a bench warrant for failure to appear in court. So the police officer, he has two options. He could write you a citation and say, hey, you better appear in court on this date or else it's not going to go well for you. Or the police officer could say, sorry, I got to arrest you, got to take you in. And that really stinks if he does that because, since you had a warrant out and you had not appeared on it for about 4 or 5 years or however heck long it's been, it's very possible that you could be held without bail until you see the judge. And that's very unfortunate for a petty theft case because petty theft is a misdemeanor. It's a violation of Penal Code Section 484 that carries up to 6 months in the county jail. Now, unless you go to trial, almost nobody will receive that kind of punishment. Even if they have all the evidence against you, worst case scenario, you might get a couple of years of informal probation, have to pay some fines, maybe restitution. You might have to do a little bit of sheriff's work, which is similar to community service, except that it's under the auspices of the sheriff's office in the county where the matter took place. Now, what really stinks is if you had the bench warrant from a different county, that's a problem. Because if you have a bench warrant at a county, a lot of times you can be arrested and you can be stuck in custody and they'll keep you there maybe for up to 2 weeks until the other county comes and picks you up and takes you before the court. That does happen. So what I would advise you, this is really important, if you think you might have a warrant in the system, if you had been accused of a crime in the past, it'd probably be a good idea to check the court records because you don't want to be, you don't want to be caught like a deer in the headlights, so to speak. If you do have a warrant, be sure to add your matter on calendar, talk to a criminal attorney so that he can deal with it, or you could contact a bail bondsman if there is an actual bail amount so that you could just take care of the warrant and then afterwards contact an attorney. But I recommend if you have been accused of a crime in the past, if you've been arrested in the past, and let's say your matter didn't get dealt with, you should really verify with your county to see if you have a warrant in the system because you don't want to get arrested at a county and then end up in this situation. So regardless, if you have any questions regarding criminal law, if you'd like to learn more, be sure to subscribe to our channel, Law Offices of Cross and Associates. But if you've been accused of having committed a crime, be sure to give us a call at 1-800-862-7677. Once again, 1-800-862-7677. This is Alexander Cross, attorney.